First of all, let's address some of the misrepresentations, the false reporting issue that was used to sort of wave the flag in front of you and get you upset. You have to intentionally file a false police report. There isn't negligent filing of a false police report. And I do think that it is inappropriate to focus on whether or not the people of Richmond, as been represented here, have a positive relationship with their law enforcement officers. This isn't about Richmond, ladies and gentlemen. It's about Arcata. It's about Eureka. It's about San Diego, Santa Barbara, Los Angeles. Pick any other community in the state of California. Do not be misled by whether or not the people of Richmond are feeling warm and cozy and fuzzy with their law enforcement officers. This issue is much bigger and much more significant than that. When I attended law school, one of the things that people would use in order to try to distract those that had an obligation to make a decision about an issue was the parade of horribles. And it's a convenient exercise that all lawyers learn to do. And that is, you take every possible permutation, every aberration, and string them together all at once so that you are presented with a daisy chain of possible bad things that could happen. In my conversations with the opponents, I asked them, give me one example of a witness that had a problem with respect to reporting a crime when the victim was under 14 years of age. And guess what? They don't have any. So the argument that this is going to result in some sort of wholesale defection of witnesses is specious and has been presented to you in order to distract you from what exactly is the case here. And the situation is, this girl in Richmond was 16 years old. She could have been 15. She would have had no protection under the law. There's another version by Senator Yee that makes it 18. So who gets to explain to the 19-year-old that she was born a year too soon? And any other witness who's been assaulted, all my bill does, in spite of what you've heard here today, is strike the age. That's all. It doesn't eliminate any of the other protections that are incorporated in this legislation for people who feel that if they report that places themselves in grave danger. Those all remain as the state of the law. And I would say this, I don't know anything about the Magna Carta. I do know, when my opening statement to you, the number of other states that have taken a look at this issue and have lined up with me that the reporting of a crime shouldn't be subject to some artificial construct of an age of 14. That girl cowering under the bench after being abused for 2.5 hours obtained relief because someone else, not a witness, felt an obligation and a duty. I don't know how it was that she learned that she was supposed to do that. I don't know why it was that that person who made that phone call didn't live her life in apprehension of the Richmond Police Department. What I do know is that finally with that call, 2.5 hours of terror, because the description of this girl in some of the reports was she was nude from the waist up, crawling up under a bench to get away from the people who were raping her and beating her while 15 others, at least 15, walked by and then gathered someplace else to share stories. All I want to do with this bill is to afford for the victims of violent crime. This is not shoplifting. You don't have to go call store security if you see somebody shove a pack of cigarettes down the front of their pants. This is rape. This is murder. This is forceful, brutal sexual assault. And by expanding this legislation to include domestic partners, I think we are reflecting a change in California. Ask for an aye vote.